Hello friends, it's course 5, Real Property Law, chapter 1, History and Concepts of Property Ownership. In this chapter, first we're going to talk about historical background of laws of ownership. So as we know, Canada adopted all the laws from British Empire. So Canada first import British North America Act 1867 into their own constitution. So in July 1st, 1867, that was the day we celebrate Canada Day, and that was the day when we start using British North America Act, and it was effective on July 1st, 1867. But the problem at that time was whenever Canadian Parliament need to update or make changes to their laws, to their constitution, they need a permission from UK's Parliament. In 1981, Parliament of Canada requested to Parliament of UK to end the involvement, so that if we want to make changes to our constitution, we don't have to ask them. So what happened is UK Parliament make UK's Canada Act 1982, in which they allow Canadian Parliament to make their changes into the constitution however they want, and they don't need any further permission from UK's Parliament. And after that, the Canadian Charter of Rights and Freedoms formed, which we call Constitution Act 1982. Okay, let's talk about tenure versus estate. So in Canada, we see two land ownership systems. First is tenure, and the second one is estate. Estate is bit more newer than tenure. So what is tenure? Tenure means holding a land without owning it, whereas estate is the extent of interest or rights to possess a land. So if you occupy or buy a land, you as a person do not own the land, but an estate in the land. To explain it a bit more, we have to talk about feudal system of tenure. Through this system, what happens is king will appoint tenants in chief, because those tenant in chiefs are principal tenants of the king. They have a more right than anyone else, so they were called lord of the lands, or in today's language, landlords. Those landlords do not own the land, they just have interest in the land. So what they usually do, those landlords sublet the land to another people and make money out of it. So in return of land, those landlord will provide services to the king, like military services, or pay taxes to the king, or simply maintain the land. Originally, landlord were not supposed to sell those lands to somebody else without the proper approval from the king. But as time passes, those landlord start selling the land to somebody else. As a result, king lose control over those lands and tenants in chief, which in turn break down the feudal system. But on the other hand, it gave birth to another type of ownership, which we call estates. Now, estate is a simple term for buying a land but not owning it. That means you buy a land, you don't buy a land, you buy interest in a land, and the rights goes with it to use it in a legal way. The actual owner of the land still remain crown or king. Okay, let's talk about development of Canadian law. As we have discussed earlier, Canadian laws start from the British North America Act 1867, now part of the Constitution Act 1982. Since then, government continually adding to and changing the laws by making new one. Okay friends, now we are talking about types of estates. In the previous discussion, we have already discussed about estate. To refresh your mind, let me pull up the definition. Estate is a interest in land with bundle of rights, especially ownership. Now there are 5 types of estates. First one is estates to uses. Second one is fee simple. Third one is life estate. Fourth one is future estate, and fifth one is leasehold estate. Okay, now first one is estates to uses. As name suggests, estates for uses provide property to occupy but doesn't provide any ownership rights. For example, if son gives his house to his father without any money, rent, or without any compensation. Fee simple is the highest estate or absolute right in any real property, which means it provides most rights with the least limitations. That's why it's considered absolute right in real property. So these fee simple owners can sell, lease, or gift their land. Now there are two types of fee simple. One is fee simple with conditions, and another one is fee tail. Now fee simple with conditions has associated with a condition. It terminates the right to own the land if certain events took place. For example, if somebody allow his land for to use for the educational purposes only, if the municipality or government doesn't use that land for education purposes, that land will go back to the original owner. Now we talk about fee tail. Fee tail also has restriction. The restriction is normally associated with the transfer of the land, which is limited to the limited class of heirs. This fee tail is often found in old deeds but are no longer valid. Now number 3 and number 4, life estates and future estates, they are both related to each other, so we're going to discuss them all together. Now life estate is the estate when somebody provide you the property to occupy for the lifetime, and future estate is when somebody give you the property to occupy in future. So for example, when owner of the life estate will die, the property will go to future estate. Let's take an example. For example, if husband provide life estate to his wife and future estate to his son, then wife will occupy the house for a lifetime. Okay, now we're gonna talk about concurrent ownerships. There are two type of concurrent ownerships. First one is joint tenancy, and the second one is tenants in common. Let's discuss about joint tenancy first. Joint tenancy is the ownership of land by two or more persons and is specifically created as such with clear intention. If one owner dies, the another owner acquires the whole interest in the property. To create joint tenancy, there are 4 elements which are required and known as 4 unities. If any of this is absent, the joint tenancy will convert into tenants in common. So these 4 unities are title, time, possession, and interest. So unity first is title. All the joint tenants obtain their ownership from the same document, deed or will, and at the same time. So each owner has the undivided possession of the property without any separate rights to anyone else, and all of them must have the same interest for that same duration up to same extent. If something is different, then this is not joint tenancy. It will convert to tenants in common. Right of survivorship is an important aspect of joint tenancy. It states if one owner dies in joint tenancy, the interest of the died owner will pass on to the remaining owner of the joint tenancy. A joint tenant cannot make any will for that particular property as such, because after the joint tenant dies, the property will transfer to another joint tenant automatically. Spousal interest. Spousal interest is the exception to survivorship. Now termination of the joint tenancy can be done by 3 ways. When joint tenancy is terminated, it will automatically convert into tenancy in common. First one is voluntarily. Joint tenants can be mutually agree to cancel their relationship of joint tenancy. And third one is variance. When one of the joint tenants grant or sell his or her interest to the third party without the consent of other joint tenants, that joint tenant will be convert it into tenancy in common and lose his right of survivorship. But the other joint tenant will still remain joint tenant to each other and will have joint tenancy in common with the joint tenant who sold his interest to the third party. And the third one is partition. Partition is by the court order. If court order to split the land and divide it accordingly to the joint tenant. If splitting or dividing is not possible, court could order to sell the land and divide the money accordingly. Now we're gonna talk about tenants in common. Tenants in common is the ownership of the land by two or more persons. To form tenancy in common, they must have one unity, which is unity of possession. Any tenant in common can sell his interest to somebody else or lease it or write a will for it. There is no right of survivorship in tenancy in common. If tenant dies, his interest will become estate to that tenant. Now we're going to talk about riparian rights. Riparian rights are usually associated with the recreational properties. These are the rights specifically associated with the properties alongside the lands of the banks of watercourse. These are also known as natural rights by reason of ownership. These rights are grouped in two categories: the body of water and flow of water. So body of water rights include rights of access water, direct exclusion access from owned land, right to navigate, and right in shore area by natural growth. Okay friends, our next topic is the Family Law Act. Under this Family Law Act, we will discuss four headings. First one is what is matrimonial home. Second one, how you can designate matrimonial home. And the third one is what is family property. And the fourth one is how non-owner has the right to occupy matrimonial home. Okay, now start with matrimonial home. What is matrimonial home? Any home or property which is occupied by both spouses and it's the primary residence of the family is called matrimonial home. Now it could be in city or it could be in countryside and it could be more than one. You might have two matrimonial home. So next one is designation. How we can designate a home as a matrimonial home. The process is very simple. Both spouses has to be present and has to do it together and fill out the form to register a home as a matrimonial home. It has to be both spouses. Now the first benefit of designation is it will release all the other properties from part 2 of Family Law Act, and it will sort out the issues concerning possession and the consent of the non-owner spouse are eliminated. So what that means is if house is designated as a matrimonial home, all the other properties, the actual owner, whether it's a husband or wife, they can sell it or lease it or do whatever they want, but they don't need any consent from their spouse to perform that activity. But if next is family property. What is family property? Any property purchased during and after the marriage is called family property, excluding the gifted properties, inherited properties, or any amounts you receive from the court, and any kind of insurance claim, or any property which is explained in or discussed in domestic contract will be excluded from that net family property. So now what is domestic contract? Domestic contract is a simple agreement between the spouses which has the guidelines which property will be included or excluded if the marriage breaks down. Now if the marriage breaks down, spouse with the greater net worth has to pay to other spouse to equalize their both net worth. So the process is we have to take an example. Let's say if John has inherited a house from his parents and it's worth of $100,000, and he married to some girl, and at the time of marriage the house is still worth of $100,000. And after, let's say, 5 years or 4 years, they got separated, and the house value will be, let's assume the house value rises at to one two thousand $200,000. Now John net value will be calculated only $100,000. That's increased. That's the only increase he got from that house. So if the marriage breaks down, John has to pay half of the money to his wife to equalize her net value. So he'll pay $50,000. Now we are at the last topic of the chapter. It's a non-owner right to possession, which means both spouses have the equal right to occupy the matrimonial home. And it does not matter if the title of the home belongs to only one spouse. Both spouses has a equal right. And according to non-owner right to possession, non-owner spouse has the right to be notified of any proceedings by a third party. For example, if a bank is uh, trying to sell the house because of non-payments of the mortgage, then bank has to notify the non-owner spouse. And the registered owner has cannot dispose or sell or lease the matrimonial home without the consent of other spouses. So here we end the chapter 1. See you in chapter 2. Thank you.